Good evening, everyone. Good to see you here. It's just the same programme, well, obviously some different cases, as we have every year, Duncan and I, except, as you may have noticed, it's a different venue. And I can't promise you sausages from the pub across the road, but there will be food and drink afterwards. So, Selborne, as always, welcome you all to our annual get-together to talk about property law. As always, I will deal with landlord and tenant, and Duncan will deal with property, real property. My talk, I better make sure I don't forget the pictures. Right, so my talk, in the usual way, I deal with the common law and then statute. There are actually notes from Duncan and I have a feeling, I was told, that they're going to be emailed on to you at 6 o'clock. So I don't know whether they've already magically appeared on your system, but so you don't really have to listen to me at all, but hopefully there's some vague entertainment value. The eggs are in each case, in fact, it would be much more interesting, it occurred to me, if I left the text out of these slides and I only gave you the pictures and then you had a little quiz whether people could remember what case that is coming up. But the reason that this is eggs is because, as Lord Justice Lewison explained when delivering judgment, the agreement in question was partly contractual and partly non-contractual. And the interesting question is whether one part of it was contractual to the extent of an agreement to grant a lease. And the case is actually important, not just in the L&T field, but more generally in terms of contract, because the issue is whether when you have heads of terms, that they are to be regarded as binding at that point or simply a step on the way to a contract. So in this case, the parties had these heads of terms, and the issue was whether clause 1 did create a contract to grant a lease, and the deputy judge decided that it didn't, and the Court of Appeal agreed with her. And in his typically erudite way, Lord Justice Lewison examined the issues by reference to principle, and in fact, it might be pertinent for me to, you'll see this in the notes, if I mention clause 1 was headed lease, and it was quite short. It said, this is based on a bare land site known as the Flax Factory. The lease is for 25 years. It will be outside the 54 Act. Okay. Hopefully you could hear me before. If you're at the back and you can't hear me, you can wave. And then the lease value was said to be £150,000 a year, payable on quarter days with RPI. And there was also a clause right at the end. That was clause 1, and there were a few other clauses. And that said, these heads of terms are agreed and signed on the understanding that formal agreement will be drawn up within 1 month from planning consent being achieved and subject to consents and easements. It's agreed that Blakeney Estates and Pretoria Energy, the two parties, recognise that the arrangements being negotiated are exclusive to both parties until the 31st of July, and they agree not to enter into negotiations with any third parties. And that last bit, the last sentence in the final clause, was agreed to be a binding lockout clause. So that's the egg part where there was a binding agreement. The judge, as I say, the deputy judge had decided that there was not a binding agreement in relation to the terms of the lease. And in reading from what Lord Justice Lewison had to say, I'm particularly picking up little bits of it. He said it depends not upon the subjective state of mind, but what was communicated by words or conduct. In other words, you look at the matter objectively and you ask whether the parties intended to create legal relations and agreed all the terms. And he actually had something to say about heads of terms. And he said, the label heads of terms is not conclusive. A document referred to as heads of terms may be intended to be a non-binding record of the broad principles of an agreement, or it may be intended to be a binding contract governing the parties' relations. And then there's lots of other cases they're referred to. So if you have one of these situations where there's an issue as to whether the parties in their heads of terms have actually bound themselves, then this is the case to turn to. There's one more twist. So on these heads of terms argument, as it were, it was agreed that in any event there wasn't a binding contract to grant a lease. But Lord Justice Lewison took the opportunity to opine on another reason to decide that there wasn't a binding agreement for a lease. And he said, the time from which the term of a lease is to begin is a term that the law regards as essential to the creation of a binding contract for a lease. So although the heads of terms mentioned 25 years and quarterly rent reviews or quarterly payments and that kind of thing, they didn't say when the 25 years started. So that alone, even if everything else had been sufficiently certain, was a reason to find that there wasn't a binding contract. So that's quite a useful little twist that you might be able to pick somebody up on in a problem that you have. So that's that case. I now move on to remembering Cherry Tree. So it's about 10 years since we had the Cherry Tree case. So the AHGR case in Cain Laverick, they were two brothers, is rather pertinent. This is the case that involved the construction of the phrase live/work in a user clause in a 999-year lease in something called the Bickles Yard development in Bermondsey. And it was a mixed-use development of flats, offices, and there was one live-work unit. And the issue was whether that meant live or work, or live/work, as the landlord contended, or as was found by the judge at first instance, His Honour Judge Johns, as live and or work. And the landlords were very keen to show that these two brothers were in breach of the user covenant, but they failed at first instance, they failed on appeal, and then they failed in the Court of Appeal. The reason I'm actually mentioning this case is because, particularly when it gets to the Court of Appeal, the leading judgment from Lord Justice Dingemans, I may have mispronounced his name, for which I apologise, he referred specifically to Cherry Tree Investments. And you may remember that's a case where you're having to consider what is material as an aid to construction. And where you've got something like a lease, which creates an interest that is ongoing, or company articles, then you don't look at everything, unlike the principle that everything's material is by way of background. Under Cherry Tree, you can only have regard to things that are publicly available. So you can look at a planning permission because that's publicly available, but in this case, the planning permission was admissible, being a public document, as an aid to construction, but other things weren't. There was some planning guidance and there was a planning officer's report, and they were peculiar to the parties. But of course, this is a 999-year lease, so it was going to go on for a very long time. And so the other things that were available, but were not admissible as an aid to construction. So that's the AHGR case, and that is a Cherry Tree, so I'm reliably informed. Now, this, I suspect a lot of you have already come across. This is the Sarah and Hussein and Blacks case. It's interesting, particularly because of the way that the decision taking by the courts took place. You had a clause stipulating, this is a service charge scenario, a clause which said that the landlord would provide a certificate, quote, as to the amount of the total cost and the sum payable by the tenant. And then phrase that you've probably come across, in the absence of manifest or mathematical error or fraud, the certificate would be conclusive. And so you had different viewpoints advanced as to what that meant. And you had an argument before the Deputy Master, you had an argument before the Deputy High Court Judge, you had an argument before the Court of Appeal, and then when it gets to the Supreme Court, you had 4 of the judges coming to a decision that was neither advocated by the landlord or by the tenant. And the Supreme Court said that the resolution to this was pay now, argue later. So you get the certificate, you have to pay, it's a sort of cash flow point, but then you can argue about what really you have to pay by way of service charges in a later fashion. They didn't go into lots of detail about how you would, but it was treated as cash flow. Now, Lord Briggs, who of course is a recognised real expert when it comes to property and chancery, he did not agree, and he went as far as to dissent from the other four. And he said he could see no support for pay now, argue later within the language of the lease. He said it's not a construction thus far identified by any of the courts below or proposed by either of the parties. It is an imaginative creation which the parties could sensibly have agreed to meet most of their respective concerns. But in my view, it is not to be derived by any process of construction of the terms of Schedule 6 that they actually agreed. So imaginative in the way of the genie, but he wasn't. So it was obviously quite a strong thing to say he wasn't going to agree with the other four. And if ever you have to advise clients, as I'm sure you do, what the result of the case might be, this only gives a further twist, because you can imagine, I do sometimes say to people, if you can get permission to appeal, all bets are off. Sometimes it's really difficult to get permission to appeal or permission for a second appeal because there's very rigorous scenarios. But once you overcome that large hurdle, you then all bets are off. And of course, in this case, it happens it was the minority because he wasn't able to carry a couple of the other judges with him. But if it had been, you'd get the scenario whereby a decision is based on a construction that isn't there to be found by the wording at all. And yet four people say, it doesn't matter what the wording is, this is the sensible way forward. So that is grist to the mill if you have arguments with your opponent. You can come up with a construction that you don't have to justify by reference to any of the words. You can say, no, the sensible common sense way to make this lease work is as follows. Supreme Court may be very elevated judges, so perhaps they can do that, whereas I'm not sure any of us in the room would be brave enough to do so. So that's the current way that you get to questions of construction being worked through. Now I'm moving on to a case about a nursery, and the underlying facts are, as you'll see I say in the notes, commonplace. There was a nursery and it didn't pay its rent, and so the landlord re-entered, quote, peaceably, but perhaps particularly because it was a nursery, and I imagine there were children who were going to have to resort to the nursery. Quite what happens when you re-enter on a nursery, parents all roll up with their little ones and then the nursery is shut. The nursery acted very quickly and they toddled off to the court. The re-entry was on the 26th of August last year, and they went and they got an injunction by the 5th of September. And then it was continued into parties, and then there was an appeal, permission to appeal was granted. Now, you would have thought that's rather obvious. I mean, the balance of convenience is so plainly in favour of the nursery continuing in the meantime. And it was agreed that the American cyanamide criteria applied. So as I say, balance of convenience plainly went together with the tenant, but the landlord argued that in fact there was no serious issue to be tried, that the nursery still had a tenancy. And the landlord wanted to argue and did seek to argue in the Court of Appeal that there was an estoppel by convention that there was no tenancy. And Lord Justice Lewison, you might imagine, came up with a whizzo ploy to defeat that argument. He said, I'm now quoting, "If there is in fact an actual tenancy to which Part 2 of the 54 Act applies, then the statute overrides any estoppel. And therefore, if the nursery succeeds at trial in showing an implied periodic tenancy from the taking of possession and payment and acceptance of rent, there's a strong argument that estoppel by convention cannot override statutory security of tenure." And so the landlord, cunning though his argument was, it was even more cunningly met by Lord Justice Lewison by advancing this contention that you can't, as it were, stop yourself out of the 54 Act. Again, I mention that because that could well appear in many possible scenarios. So those are the cases that I'm going to mention in relation to the common law, but there actually have been a number of important cases dealing with statute law. And so I'm now going to move on to those. And I've got a couple of cases, I think, that I'm going to mention, yes, about the 54 Act. this is probably the more important case, again in the Court of Appeal, and this is a case where there was opposition to the grant of a new lease, not our tried and tested friends little f or little g, but this was A, B and C, all opposed, all different fault grounds were being advanced as to why there shouldn't be a new lease of the premises. And there were two questions of really principle that were why this matter got to the Court of Appeal. One was, what date do you look to consider A, B or C? And then also, how do you actually deal with a case where you haven't just got one ground of opposition, little a, but you've got several? And you'll see in a moment from what I'm going to say, or you'll hear in a moment, that in an earlier case, it was suggested that you compartmentalise A, B and C. And with a little relish, Lord Justice Lewison said that a lady I'll mention later, Lord Justice, got it wrong. So, so what you had in this case is you had a trial before Judge Monty at Central London near here, and he decided that the date when the landlord's counter notices had been served opposing the grant of a new lease, the premises were in substantial disrepair, and furthermore that the tenant had persistently delayed in paying rent. But he said that the substantial disrepair had been remedied by the date of the hearing, and the delay in payment of the rent was now minor and would not recur. And there were some other breaches of covenant, but they were also minor. And so he said, looking at all the circumstances together, that and having regard to the change and looking at the date of the hearing, it was a question where the wording of A, B and C is ought not to be granted. And he wasn't prepared to say that the tenant ought not to be granted a new lease, and so he did so. There was an appeal to Mr. Justice Richards, which was dismissed, and so it finished up another one of these cases on a second appeal before Lord Justice Lewison. And he dealt with the timing issue first, and he said, what's happened between the date of the notice or counter notice and the date of the hearing is plainly relevant, and doubtless in many cases it will be given considerable or even decisive weight. So what in practice has happened is we've gone a long way towards Betty Cafes, which is the one that applies for F and G, which is you look at the date of the hearing. So they haven't said in terms, it's the date of the hearing. But when you've got a judge saying could be considerable or even decisive weight, that's a pretty strong steer that you are having regard. So if you've got a client who's a tenant and there's an objection on these grounds, then you bully the tenant in a polite way. You bully the tenant to come along, do the repair work, pay your rent and get yourself together, because then you will hopefully get a new lease. Now, that was the first issue, the timing issue. The other issue was whether you compartmentalised A, B and C. And in a case called Yusufi and Musselwhite in 2014, which I vaguely recall talking about in a previous incarnation of these talks, you had Lady Justice Gloucester, and she said that the grounds, and that was a case with opposition on A, B and C, should be compartmentalised. And Lord Justice Lewison said he didn't agree with that, and in fact he agreed with Mr. Justice Snowden in a case called Kent and Guest, who had said this: the relationship of landlord and tenant is a unitary contractual relationship, and the compartmentalised approach to sections A, B and C could have unjust results. The most obvious is the tenant could breach the covenants under A, B and C, but if viewed separately, it might not mean he should be denied a new tenancy. But if taken collectively, as would actually be the position in practice, the landlord would be saying, well, wait a minute, you know, I don't like this tenant. This is an unsatisfactory tenant, not just because of this, but this and this and this. You take them all together. And so that is the approach now. So for those of you who've been giving advice to clients on the basis of Yusufi, you now, obviously you can't undo the advice, and it wasn't wrong at the time because you were relying on the Court of Appeal decision, but you now forget about that and you move on and you have regard to this case, Jill and Lee's news. So once you've got to the stage when it's decided, well, I've gone on too far. No, I haven't. Once you've got to the stage where it's been decided or agreed that the tenant would have a new lease, then issues arise as to what the terms of the new lease would be. And one of the commonplace scenarios that crops up is in relation to break clauses and whether the landlord should have, because often landlords aren't in a position to oppose, or maybe they missed out the chance to oppose the new lease under ground F. And yet what they want to do is they want to have in their pocket the opportunity to break the lease in the future. So you get quite a lot of cases where the landlord wants to include a break clause, and there's a little known book about break clauses which has got some text in, which I'm not going to mention. It would be wrong of me to do so. And in fact, I was appalled to find in reading the judgment of B&M Retail that there's no reference to this textbook at all. But virtually all the cases that are reviewed in the textbook are dutifully reviewed by Mr. Justice Miles in this case. And the reason I'm really mentioning this is that, forget about the textbook, but there is a review in this case of all the relevant authorities as to whether there should be a tenants break clause or not. And the tenants break clause had been included by the judge in first instance, and Mr. Justice Miles dismissed the appeal and said on balance it was appropriate to have the tenants break clause. Yeah, that's the roller, so these are the property guardians. There's a company called Global 100 Limited, and they've actually been involved in other cases. There was a case about lease license, which I talked about last year, where Global 100, and about the test for arguability of whether there was a tenancy or not. Quite an important case for the everyday cases where you go rolling along for the 15-minute list. And can it be established that there's a sufficiently arguable case that someone's a tenant? And the Court of Appeal addressed that issue. This is another issue, but a rather different twist, because the issue here was whether the use made by the property guardians of their living accommodation was the only use of the accommodation, because the issue there was whether you had a house in multiple occupation. And the curious thing is my understanding of property guardians was that you'd have a big old office or big old, whatever it was, not obviously blocks of flats, but something that was quasi-derelict and closed down. And in fact, there's a fire station. I go past this and I drive home every day. And you've got one or two people in who would put up on a camp bed or something who were supposed to be genuinely there to guard the premises. But seemingly Global 100 have hit on a much better plan. And so there were two properties concerned in this case. One of them was in Stamford Brook, and the Global had converted the defunct offices into 30 bedrooms, 4 kitchens, 4 lavatories, and in fact, they packed them full of people who were living in all this accommodation. And I'm just quoting from the FTT decision. These people had no responsibilities as property guardians save to live in the accommodation. So they had no obligation to act as security guards or anything like that. So I've included it because it got to the Court of Appeal, but the Court of Appeal, effectively, it looks to me, were just looking at the factual findings, and the factual findings were that Global 100 were essentially using this as accommodation for packing it full of people to sleep in. And so it was found to be a house in multiple occupation. So, but there may be less extreme cases that come to you because the penalties, and I'm not going to talk about that today, my fellow spokesperson, Duncan, has cause to be hit occasionally. Well, he has personal experience of HMOs, so I don't want to be insensitive about it. But lots of these cases about HMOs are coming to the fore, and including things like the number of people you can have. If you have 3 or more occupying accommodation, then you tip over into being an HMO. Not members of the same family, but just ordinary folk who don't know, who just come together to share accommodation. Now, I think the next case, and I think it may be the last case. I don't know why this roller keeps coming up. Oh, that's it. The roller is desperate to appear. So anyway, so I now come to this case, Aviva and Williams. This is a case that got to the Supreme Court, again by a detailed route via the FTT, the Upper Tribunal, the Court of Appeal, and then got to the Supreme Court. And interestingly, the Supreme Court upheld the FTT, but thought the Court of Appeal was rubbish. So this case considered section 27A6 of the 1985 Landlord and Tenant Act. And that's the one that says an agreement by the tenant of a dwelling, ... is void insofar as it purports to provide for a determination in a particular manner or on particular evidence of any question that may be the subject of an application. And you often have the facts of this case were pretty typical. You had a provision for the apportionment of service charges to leaseholds, and it was either a set percentage or it was such part as the landlord may otherwise reasonably determine. And the FTT said, well, they just took it at its words and they said, that's okay. And all we have to do is look at the discretionary part of it and ask ourselves whether the landlord has reasonably determined that percentage. In other words, we don't strike anything down, we just use the language. Now, the upper tribunal disagreed, and they thought the discretionary part, such part as may otherwise reasonably determine, was void. And so the result was you were just left with the fixed percentages. So that rather changed the bargain in terms of the lease. The Court of Appeal went in a different direction, and they said the discretionary part wasn't void, but when it said such part as the landlord may reasonably determine, we knock out the landlord bit. And so what we have is such part as the FTT may reasonably determine. Now, the Supreme Court got very concerned about the ramifications of the Court of Appeal's decision, because what that was essentially doing is it was taking away from landlords all kinds of decisions that depended on their discretion and took it away and gave it to the FTT. Now, the FTT, I don't confess to have enormous experience of it, but I don't find them to be a particularly quick jurisdiction, and they're quite busy. I mean, they've got a lot of work going on. This would have given them far, far more work, because every time there's somebody who, for example, wants to change a percentage, then you'd have to toddle off down to the FTT. So the Supreme Court went back to what the FTT had said, and they said, well, I won't read out the quote because it essentially says that the section I read out, whatever it is, subsection 27A6, it doesn't strike down such a clause, so you're left with the FTT simply asking itself whether the percentage has been reasonably determined. So it's sort of like it's like a review provision that the FTT is operating, rather than doing all kinds of damage to the words. But if ever you needed another basis or another case to illustrate how, when you go to the next level, you can finish up with a different decision, this is another example of that. 4 different levels and different results, except for the first one, as you go along. So do not be daunted when you have a case. Always advise the client that you need to go to counsel, and then if you've lost, you advise an appeal, and then you advise another appeal. And if you can get to the Supreme Court, you might finish up with a decision in your favour, even on a basis you've not argued. And with those words, I'll turn you over to Duncan. Thank you very much.
Thank you, Mark. I'll try to go forward, not back. Yeah. And my name's Duncan Kynoch. Good evening. In fact, Mark's last words on inconsistent decisions at various levels of the courts is exactly this case, the Fern and Tate Galleries case, which has kind of been done to death in the commentary. But you had I think 9 judges looked at the case. 6 judges decided at first instance and Court of Appeal level that there was no nuisance. 3 judges in the Supreme Court decided there was a nuisance. So 3 out of the 9 decided there was a nuisance, and unfortunately for the defendants, that those 3 judges were in the Supreme Court. So the result was there was a nuisance. So perhaps underlines Mark's point that there is, when clients complain there's no predictability in litigation, well, quite. As our old senior clerk used to say when counsel had given advice and the case lost, he said, well, I'm afraid that's one of the vicissitudes of litigation. So it is an uncertain process. But I'm going to talk to you about real property in the last 12 months. There's been the usual drumbeat of rights of way, rights of light, cases, adverse possession, injunctions against the full kaleidoscope of human behaviour, including new types of strange behaviour, such as people sticking themselves to things with glue. And there's been a lot of telecoms cases in the last 12 months, but on the basis I'd quite like you to come back. I'm not going to talk about telecom masks or anything else. The two significant cases, probably the most prominent cases, this case, Fern and Tate Gallery, which I'm sure you've all read about. And the other case is a proprietary estoppel farming case called Guest, which I'll come on to talk about. But Fern, you can see on the picture there that the flats on the right, very expensive flats with full wall glass walls, were built first. And then in 2016, the Tate Gallery opened a 10-story extension which incorporated a public viewing platform offering panoramic views of London. Very sad, actually, but some of you may come across that there was a child thrown off that, or pushed off, I think, who I think fortunately survived, but that's got nothing to do with the case. But you can see there that the flats are about the same elevation as the public viewing platform, and the viewing platform had up to 500,000 visitors each year, about 30 meters away. So these wealthy flat owners were eating their muesli and being constantly observed by people in the viewing platform. Most people just take pictures of themselves these days. So that's not a nuisance, but some of them were posting on social media pictures of themselves with these people in flats behind them, and that was beyond the pale. So there's a lot of peering into flats and posting photos of on social media. So the appellants who lived in the flats sought an injunction to stop the intrusion, alternatively damages. The trial judge dismissed the case on the basis that intrusive viewing from a neighbouring property could in principle constitute a nuisance, but he found it did not do so in the present case because Mr. Justice Mann found that the viewing platform was a reasonable use of the gallery's land, and the appellants could have protected themselves against the nuisance by lowering their blinds or installing net curtains. So he said claim dismissed. The Court of Appeal also dismissed the appeal on the basis that mere overlooking could never arise to a liability in nuisance. But as Mark says, you keep trying. If you get to the Supreme Court, keep rolling the dice, anything can happen. And in fact, that's what did happen. The Supreme Court, despite the previous 6 judges saying there was no nuisance, said it was a very simple case of nuisance. Can't believe you all got it wrong. So Lord Leggett, who gave the leading speech, said it was a simple case of nuisance where it was a substantial interference, people taking photographs, and would interfere with the flat users' ordinary use and enjoyment of the flats. It was foreseeable. A significant number of people would take photographs, and the gallery could not rely on the usual give and take between neighbours, because what they were in effect doing was inviting members of the public to look out from the viewing platform, which was, as the court found, an exceptional use of the gallery's land. It was not a necessary or ordinary incident of operating an art gallery. So the headlines from Firm are that in terms of nuisance, anything which materially interferes with the ordinary use and enjoyment of neighbouring land by a property with a legal interest in that land was capable of being a nuisance. The interference had to be substantial, judged not by what the claimant found annoying or inconvenient, but by the standards of an ordinary person in the claimant's position. So the fact that I find my neighbour annoying, it is not a nuisance. It's got to be an objective standard, in effect. So that's Fern. I now move on. I thought I'd stick at the beginning of this talk to nuisance. And the next case, Davis and Bridgend County Borough Council, is a Japanese knotweed case. Now, if you're buying a property, you must look out for this invasive, nasty weed, because it's the least favourite plant of mortgage providers. There's always been an argument about whether it's usually councils, local authorities, who have these vast tracts of land which they do nothing on, and there are often Japanese knotweed type invasive plants lurking on these derelict pieces of council land. And if they get onto opposing land, they can get into buildings and essentially make properties unmortgageable. And in this case, the claimant sued the council for allowing or not cutting back and preventing the knotweed from entering onto his land. First instance, the district judge dismissed the claim on the basis that the diminution in value of the land claimed by the claimant was not actionable in law. The circuit judge also found against the claimant on the basis that he said the invasion and the diminution in value of the land was pure economic loss, as he found it. And to underline again what Mark has said, third time lucky, the claimant won in the Court of Appeal. The Court of Appeal said the key point about why the knotweed was an actionable nuisance was it actually got onto the claimant's land. So there was damage to the land itself. And so it was not economic loss or pure economic loss because there was damage to the land itself. So the previous two judges got that wrong. And that's what I derive from that case. The next case, Guest and Guest, another Supreme Court case. It's a farming case. It's the standard intergenerational dispute between, well, I say standard, may not be in most families, but they're quite prevalent. Father usually gives assurances to his son or daughter, you stay on the land, one day it'll be yours, that type of thing. No need to worry. And they work for low wages, usually for decades. And in this case, the claimant, I think, had worked for 30 years. The eldest son worked manfully in the fields on this farm throughout essentially his working life. Then he fell out with his parents, sadly, and he was cut out the will, brought a claim for proprietary estoppel. And the Court of Appeal allowed the claim on the basis the touchstone of all these cases is unconscionability. They don't like people going back on promises. So if you can establish the promise that one day, my son, all of this will be yours, if you can factually establish that, and you go back on it, and someone has suffered detrimental reliance, then the claimants are usually in a good position. The difficulty often in these cases is what's the remedy? Because the remedy often means, certainly if you're going to impose a monetary remedy or a transfer of some of the land, it often means selling the land. These farmers have been farming these properties for 50 years. So the remedy is often difficult. And the Court of Appeal said that one of the remedies that you can come up with is to give the parents a life interest in the farm, so they live there till they pass, and then the son gets a reversionary interest in the land, and that's often a softer way of delivering the blow to the parents. You have a life interest with a reversionary interest in favour of the claimant, but the Court of Appeal said that the normal starting point on remedy is to hold the promisor to the promise. So whatever he's promised, or he or she's promised, you hold them to the promise. And then you work out, well, is that out of all proportion to, or is going to cause too much detriment to the promisee? The court might be constrained to limit the extent of the remedy by having regard to the detriment. The other issue that you always need to consider in these cases is the promises are often made when I die, you can have X, Y, and Z. And so that's a future promise which has to be assessed by the court in advance. So there's a question of accelerated receipt. So the claimant always generally has to accept an element of accelerated receipt by way of a discount. So there has to be a discount because he's receiving the benefit in advance of when the promise was supposed to take effect. Because evidently the defendants, the mother and the father, are generally alive at the time of the trial. So accelerated receipt was one of the errors that the first instance judge didn't take account of. The other point to derive from this case is if there's two ways of giving effect to the unconscionability, it was in principle for the defendant, for the party to whom the equity was asserted, to make the choice. So the parents in this case had the choice of whether to accept a monetary amount in favour of their son or the reversionary interest with a life interest as the remedy. So that's guest and guest, proprietary estoppel case. The next case, Power and Shah, is a party war case. It's not everyone's favourite topic, but I'll touch upon it briefly. Very few party war cases get to the Court of Appeal. But this was a case where the claimant carried out works for which he should have served a party wall notice. He didn't, so he did nothing other than do the work. And he didn't take the benefit of the Act, because the Act, the 1996 Act, engages the machinery of the Act, and it's a dispute resolution machinery. So you serve a notice either under Section 2, Section 3, or Section 6 if you're going to excavate near the boundary. And but the first step in any party war case is the service of a notice. Now, the unusual thing in this case was that the claimant did not serve any notice. So the Act itself was not triggered. It was not, the machinery of the Act was not engaged. And that was the point, that was the fallacy or the mistake that the defendants made in the case, because even though the claimant had not triggered the machinery in the Act by serving a notice, they appointed surveyors who published an award, which is the usual mechanism for settling differences under the 1996 Act. And the award was served on the claimant, and it was against the claimant, so there was compensation, there was surveyor's fees. And so the defendant was saying, well, you should have served a notice, and here's the award, and you've now got to pay me compensation and fees. The claimant said, the Act is not engaged because I didn't serve a notice. So the award is a nullity, was his position. And that argument found favour both in the county court and in the Court of Appeal. The Court of Appeal dismissed the defendant's case on the basis that the dispute resolution procedure under the 1996 Party Wall Act was not engaged unless the building owner had served a party structure notice on the adjoining owner in accordance with Section 3. And so the building owner succeeded, even though his behaviour was arguably less deserving of merit. But the adjoining owner, so that's the owner of the property whose property has been affected by neighbouring works. Now you might say, well, what could he do where there was no notice served? And the answer is that the adjoining owner whose property is damaged has a common law claim to trespass, nuisance and or negligence. And that's the claim that they need to advance. The adjoining owner needs to advance that common law claim if no notice is served. So the headline from Shah is that whenever there's a party wall dispute, you need to be very clear as to whether you're dealing with a common law, trespass, nuisance and negligence, or the 1996 Act. So in cases where there's no notice served, you're dealing with the common law. And obviously where a notice is served, then the common law is substituted. So you've got to make sure that you're riding the right horse, if I can put it that way, common law or the 96 Act, when you advance a claim or an appeal against a party wall award, because otherwise you'll end up in the position of the parties in Shah, where the award was held to be null and void because there was a misunderstanding as to the operation of the Act. And the slogan in the Court of Appeal, I think, was used, no notice, no act, is the headline. So no notice, no act. And that perhaps sums it up. The next case is Bucknell and Alchemy Estates. It's a right-of-way case, and I simply refer to it because very often right-of-way cases come up, and they're adverse possession, right-of-way, rights of light. They always come up every year, and you need to know how to deal with them. Often it's a case of just looking at the express grant. So you look at the words in the express grant, and you put them in their physical or the locus of the grant, and that gives you your answer generally. This was a case where the express grant was for a right-of-way over a driveway at all times and for all purposes, so a pretty wide grant. The user had always been agricultural, and the claimant complained that the defendant, who was trying to put up a few houses, so residential property development, the claimant said, well, that's excessive. That's beyond the wording at all times and for all purposes. The Court of Appeal said the right-of-way under an express grant is not to be restricted to such uses as were reasonably required at the date of the grant, and change of use from agricultural to residential use did not fall outside the scope of the right granted. And this extended to demolition and reconstruction of buildings and the use of way for construction traffic. So the claimant lost, and I simply mention it because it's a case, a right-of-way case, which although is not the most exciting case, but you do need to know how to deal with them. The next case I've mentioned, Shill Properties and Bunch, simply because I know there's a few conveyancers attend this lecture, and the point in this case was that the buyer, so the purchaser, tried to entice the seller by saying, I'm a cash buyer. And the seller was pleased with that because, of course, there's no chain and wonderful to have a cash buyer. In fact, it was all, as the Americans would say, baloney. He needed a mortgage and was not a cash buyer. And the long and the short of it is that the contract of sale was set aside on the basis of a fraudulent misrepresentation by the buyer that he was a cash buyer when he wasn't. So I draw that to your attention. Now, I've drawn a number of cases to your attention, which you'll probably say, well, that's not going to affect my life, and why do I need to know that? I sometimes think it might be better to draw attention to matters which perhaps do not change property law, but may change practice. And I draw attention to a change which arrived on the 1st of October 2023. So we're 2 months in, and this may surprise some people, into the fixed costs or the fixed recoverable costs regime, which will, I think, have a big effect on property cases and indeed litigation in general. If you're wondering what it is, the fixed cost recovery or fixed recovery costs regime will apply to all civil claims where proceedings are issued after the 1st of October 2023, with some exceptions, personal injury claims, for example. Fast track cases, so cases of more modest value, will be assigned to 4 bands. Band 1 will be disputes with the lowest complexity and will have lower fixed recovery costs. And band 4 will be the most complex cases. There's going to be a new intermediate, so it's not just fast track, multi-track, there's a new intermediate track claim, which will be valued between £25,000 and £100,000. Again, 4 bands with their perceived complexity. The parties are going to be expected to agree the appropriate band at an early case management stage. But the court can intervene to assign a different band. Fixed recovery costs will generally not apply to claims over £100,000, which will continue to be allocated to the multi-track and be subject to cost budgeting. But cost budgeting, therefore, is unlikely to continue in cases under £100,000. So pleased. I loved cost budgeting. Anyway, that was a few years of my life that I'll never get back, cost budgeting. But it's more of a burden for solicitors, I think, having to produce those schedules. But anyway, under £100,000, you may be saved a job. But anyway, I'm sure you're all very aware of the fixed recovery costs regime. But if you're not, there it is. The last matter that is probably I trespass on matters which are not real property, but I draw it to your attention because I think it's one of the biggest changes in the last 12 months. There's the explosion, literal explosion of cases in the first tier tribunal, what are called rent repayment orders. I don't know if people have come across them, but it's the government. I say nothing against Michael Gove; he's a very clever man, but the government have. There's a welter of new regulation which is ensnaring landlords all over the place. And you might argue that the UK is now, certainly England and Wales, is not as favourable as it used to be for the private amateur landlord. It's almost impossible now for the private amateur landlord to comply with all the various regulatory burdens on him, including, for example, just trying to discover whether a tenant is lawfully in the country. You might have thought that was something the Home Office might be doing, but the Section 21, the attack on Section 21 appears to have been met and kicked into the long grass for a while. But private landlords are now faced with these rent repayment orders, which are draconian, non-compensatory orders, where if a residential property is let to 3 or more people, not in the same family, So let's say you've got 4 people in a flat, and I imagine there's a few private landlords in this room, and if there are, you should pay attention to what I'm about to say. You're generally going to need a HMO license for 3 or more people, unless it's a family. And local authorities have worked out they can make vast sums of money claiming license fees. So most London councils now have a licensing scheme, and the cost can be £500 to £1,500. So it's a great revenue generator for local councils. And local councils have taken to tipping off tenants that landlords may need a license. And what that has generally led to is an explosion in claims by tenants. So these are claims by tenants under the rent repayment order legislation. And if you don't have a license, an HMO license, 3 or more people, private rented accommodation, you are liable to pay the entire rent back. So it's not compensatory, it's punitive. So you might think, well, the landlord's got a mortgage and he's got expenses and so on. Well, tough. And the first tier tribunal my assessment is 30% of their cases are these rent repayment order cases, and they're landing at about 50% to 75% of the rent is being paid back to tenants. So a tenant can live somewhere for a year, wonderful property, but there's no license, so he gets all the rent back. If you're a landlord, go and get a license, I think is the headline. It's a criminal offence as well, just to lay the boot in even more. So criminalisation of landlords and taking all their rent back by tenants, even though there's no connection between any damage and their loss and compensation is completely irrelevant. So I would, if you've got any landlord clients, send them an email in the morning saying you better get a license. So I shouldn't laugh, it's a very serious matter. Anyway, I think that concludes, I've probably gone over time, but thank you for listening and thank you for coming, and hope to see you for a drink shortly.
Indeed, I'll endorse that. It's amazing that Duncan touched on that. It's a topic he has no knowledge of, no personal experience at all. He should have disowned that. Anyway, yes, we have some food and drink, and it's great that you're here. I hope you like our new venue. Hopefully we'll be back here in a year's time. All the very best.